So let's start from what is meant under debt collection in Italy. I mean, the aim of debt collection, as we all know, is to recover total or part of the debt from the debtor. And there are, of course, two means, like in many other jurisdictions, to collect your debt, by extrajudicial means or by judicial means. What is necessary in Italy to start with the extrajudicial means? First of all, a letter of notice to comply that represents, let's say, the amicable way to start the debt collection. Then we would also suggest to have a debtor search with regard to the proper name, the address where he's residing, if he moved or not, because this may have also an impact on how successful your debt collection will be. Information on the debtor's country, I mean, in order to establish also which is the legislation applicable if there is no agreement between the parties. If there is a contract, usually the contract provides which is the legislation applicable to the parties. Then the attempt of an extrajudicial recovery, if possible, following the receipt of this notice to comply. And if this fails, of course, you can proceed with a legal action, as we will better explain in the following, and the enforcement before a judge or an arbitrator. And in the event that the debt collection is not successful, you put the claim at loss when the claim is considered unrecoverable. So the first thing first is, as said, the letter of notice to comply, which is basically a formal warning by means of usually written, drafted by a lawyer, by means of which the debtor warns, the creditor warns the debtor to pay the amount within a certain time. Together with the warning, the lawyer also asks for the payment of his legal fees for advising the creditor in collecting his debt. So the first thing then, in order to do so, is to collect all the necessary information concerning the claim, the debt, if there is a contract or a written agreement between the parties, if there are invoices, checks, or promises of payments between the parties that have been exchanged, since this has also an impact on the judicial means that you can use to collect your credit. As said, once collected all this information, the lawyer usually drafts this notice, so-called messa nora in Italian, by means of which the debtor is warned to settle the debt within a certain time, which is usually said 8 days, 8 calendar days. The purpose of this letter is, first of all, to determine if the debtor intends or not to pay the amount. Very usually in the practice, the debtor either doesn't answer or he comes back proposing to pay in settlement, which is very often, which is what often happens in the practice. And the formal notice has also some other legal consequences, which are very important. It suspends the credit prescription, because every credit has a so-called prescription. That means the time that elapses, and after this time has elapsed, this time is provided by the law. It may, depending on the credit, it may goes from a couple of months up to 10 years. But once elapsed, you cannot pretend, you cannot claim back this credit anymore from the debtor, because it is prescripted, and determines also the effective beginning of default interest that are calculated on the debt. So when the debtor is going to pay you, it has to pay you the debt plus this default interest plus the legal fee as determined by the lawyer in the warning. If the debtor declares itself ready to pay, the lawyer usually drafts a binding agreement between the parties that settle the relationship among them and how the debt is paid, if it's paid in one installment, in more installments. If the debtor refuses to pay or disputes the claim, as it may happen, and an agreement cannot be reached, the claimant has to turn to courts to start the judicial phase. And this is very important because the first means to collect a debt in Italy, once you have clarified if the credit is based on an agreement, on a check, on a promise of payment, is the injunction decree. The injunction decree is basically a recourse that you file before the court where the creditor has its residence. And by providing the documents proving your credit, the judge, without hearing the other party, releases a decree injuncting the other party to pay the amount. And further to paying the amount, the judge also determines which are the legal fees due for this procedure. Okay. And as said, this injunction decree is based on written documents that has to be proved that the credit is already quantified, is a liquid sum of money or a specified quantity of fungible things, according to what is provided by our Italian Civil Code of Procedure, releases the decree injuncting the payment of the amount, and the recourse and the decree are served to the debtor within 60 days from the issuance of the injunction decree. Once received the injunction decree, the debtor has 40 days to pay or to claim against it. Okay, by claiming against the injunction decree, the debtor basically starts an ordinary procedure before the court, while the injunction decree is considered, let's say, a simplified procedure in order to recover your debt. It's also possible that if there is a serious prejudice in the delay, or if the plaintiff files documentation signed by the debtor proving the right asserted, that the judge, by issuing the decree, allows also the so-called provisional execution. In case of injunction decree, which is also immediately executed, that can be immediately executed, the creditor doesn't have to wait the 40 days, okay, to go on with the procedure. Once served the decree, the injunction decree, there is a following act that has to be served by means of a bailiff, which is which in Italian is called atto di precetto, which is an act that is necessarily required in order to start the enforcement and to proceed with the next steps, which means the repossessions of the goods. By means of this act, the creditor gives another deadline of 10 days to the debtor to pay. And in this case, the debtor so receives this act served by the bailiff, stating the debt, the default interest, the legal fees due for the injunction decree, and the legal fees due for drafting this further act. And it has 10 days to pay, or in any case, he can claim against this further act if there are formal defects of the act, or if meanwhile some issue has arisen by means of that, he can prove that meanwhile his debt has been extinguished. If nothing happens, once served and once expired the term and there is no opposition, the creditor can eventually proceed with the possession of goods by force. That means that he can start the repossession of real estate, so he can go before the court. He has to file the injunction decree served, the other act served, and ask to start a pledge on the real estate goods of the debtor, if there is any. In order to check if there is any, of course, you have to do the necessary research before starting the action. As an alternative, he can decide to proceed on the mobile assets, which might be, for example, vehicle, car, motorcycle. These are also registered here in Italy, so that means that the creditor has to do the necessary research to check if there is any of these items that can be repossessed from his side. Or he can also check if the debtor has a bank account and proceed on his bank account. Or if the debtor has an employment relationship, he can proceed by serving a claim to his employer, asking to put aside a part of his salary in favor of the creditor, so that the debtor of the debtor pays directly to the creditor. In these cases, the salary set aside to pay the creditor cannot be below 1/5 of the overall salary, because otherwise the case law states that the debtor doesn't have enough money to live, basically. So I have to say that the repossession of real estate, it's maybe the longest. It takes time, and it takes also some other activities like the publicity in order to start the auction on the real estates that are put for sale. As an alternative, the creditor can also ask that the real estates are assigned to him. And every time that the auction goes without an offer, the amount of the auction is reduced by 1/5. This is the Italian, let's say, the Italian situation. But of course, there is also the chance that, for example, many foreign companies, they supply goods to Italy, but as a matter of fact, the contract is maybe signed with another with a company with a seat in another European country. So my intervention will also cover a little bit of European laws. What can be done? So with regard to European laws, of course, as you all know, in Europe, we have a bunch of European regulations that cover many aspects, basically all aspects right now, because everything is covered by a European regulation. So we have the regulation 805 of 2004 regarding European enforcement order for uncontested claims, the regulation 861 of 2007 covering small procedures. Sorry, go just okay here. And then the Green Paper of March 2008, by means of which the European Commission focuses more on a series of measures instead of one single European measure to allow the creditor to obtain reliable information on the debtor assets and whereabouts within a reasonable period of time. Possible measures include drawing up a manual of national enforcement laws and practice. But as a matter of fact, the most used regulation is the regulation 1896 of 2006, which rules the European injunction, which is like the Italian decree injunction, basically, but in a more simplified way, frankly speaking. The way, the timing and the way you can file it, it's much more easier, let's say, and less complicated than in Italy, which has as subject matter pecuniary claims relating to civil and commercial matter without limitation of amount and cross-border nature of the dispute. The European regulation aims to simplify, expedite, and reduce the costs of proceeding in cross-border disputes involving pecuniary claims. And it establishes a European order for payment procedure for claims uncontested by the defendant. This simplifies, speeds up, reduces the costs significantly also, because if you think that you want to start a decree injunction, you have to find maybe an Italian lawyer or who has then to appoint another lawyer, because it has you have to check also in which part of Italy the credit has to be enforced. Therefore, let's say that European injunction makes it everything more easy. And it enables the free circulation of European orders for payment, recognized and enforced in all European countries, and applies to all European countries except Denmark, which didn't ratify the regulation. The excluded disputes are those that involve customs, administrative, tax, bankruptcy, composition, and similar procedures concerning matrimonial property regime, wills and successions, like always, as well as the area of social security contribution, because this is covered by other European regulation. Also, claims arising from non-contractual obligation, except where there have been the subject of an agreement between the parties, or there has been recognition of the debt, or even if the claims relate to liquid debts resulting from joint ownership of an asset. Usually, non-contractual obligations are covered by a further European regulation. The deadlines for the European injunction are quite, as said, speedy, because by filing for the application, getting the decision, having it served, and getting the non-opposition declaration, it takes more or less 60 or 70 days. So the pros, as said, are speed, simplicity, and the costs. The simplicity, then I will show how it looks like, such an injunction. The cons are the unequal treatment compared to Italian domestic cases and possible opposition, even if not motivated. While in Italy, an opposition against an injunction decree has to be motivated. In this case, it might be not motivated, and it has to be filed. The opposition has to be filed within 30 days from getting the notice served, and it starts an ordinary process. In the following slides, you will see how it looks like. This is the application for a European order for payment. So you just select the member state to which you would like to send your form after completion. And then you fill in the form. It's very easy, I have to say. I didn't show you an Italian injunction decree, but I can assure you it's much, much more complicated compared to this. This is really a form to fill in. So it's very easy. But the European community gives us also other instruments. For example, the European Enforcement Order, which is another suitable instrument to for simplifying enforcement procedure in the European community. It was introduced by the EC Regulation 805 of 2004, so prior to the European Injunction Decree. Which is also a simple procedure that can be used for undisputed cross-border claims. The regulation provides an express prohibition for the debtor to bring an action in the member state of enforcement, which involves a review of the merits of the court decision or its certification as a European enforcement order, which, as you may understand, makes a huge difference in collecting your debt. With regard to the recovery of debt in non-European country, first of all, you have to consider that this operates according to the principle of mutual recognition, because there are no European regulations that apply, of course. And it's necessary also to verify the existence of a bilateral convention between the countries that rules how this can happen and according to which principles. With regards to China especially, there is a treaty that was concluded between Italy and China in 1991 and ratified by Italy with law number 199 of March 4th, 1994. And such treaty on judicial cooperation in civil matters applies to both individuals and legal entities, and covers all civil law matters, including commercial, family, and labor disputes, and the jurisdiction that applies is the defendant's residence, domicile, or place of business. Article 5 of such treaty provides that the covenant provisions apply to both individuals and legal entities located in the territory of one of the states, and Article 12 establishes that each party undertakes to serve judicial and extrajudicial documents upon request. Those who want to coercively enforce a Chinese judgment in Italy must proceed to its recognition before the Italian judicial authority first. Therefore, in order to determine how to proceed, it's necessary to consider which would be the normative applicable according to the Italian law on international law 218 and 1995, which establishes which is the applicable law. And Article 64 of such law established the automatic recognition of foreign judgment. We have also to consider that the treaty concluded between Italy and China provides for a recognition procedure aimed at ascertaining the requirements of Law 199 of 194, which recognized the treaty between Italy and China. And therefore, as a matter of fact, the conflict between these two opposing mechanisms is resolved in light of the prevalence of the pactual discipline provided by Article 2 of the law 218 of 1995. Therefore, it's necessary to give rise to the procedure for the recognition of foreign judgment in which the existence of prerequisites provided by the treaty must be assessed. With regard to, instead to international trade law and the recovery of debt arising from international trade law, the New York Convention of 1958 applies mainly. And it has been applied for the last 50 years, I would say, in the most successfully, since it is the centerpiece of the mosaic of arbitration treaties and legislation that guarantees the recognition of arbitral awards and arbitration agreements. For more than, as said, for more than 50 years, national courts everywhere in the world have applied the New York Convention and increasingly harmonized and uniform matter. And it has to be clarified why the parties should apply in arbitration, because this is what the New York Convention provides for. The pros basically are the impartiality of the arbitrators with regard to the litigation, the specialized expertise of the arbitrator, the shorter length, because compared to an ordinary process, the length is maybe 1/3 or even the half of it, and the effectiveness, fruitability and executivity of the decision. The cons is the high costs that arise with an arbitration, because compared to an ordinary process, the legal fees of the arbitrators are very, very high. But said that, it is really, really effective in my experience. So I leave the word to my colleague Shan Yang.